In the matter of case number 3, public hospital corrects impermissible disclosure of PHI in response to a subpoena. In brief, AU Hospital, a public hospital, in response to a subpoena that was not accompanied by a court order, illegally disclosed the protected health information PHI of one of its patients. The privacy rule protection for information requires that administrative or judicial proceedings, the hospital failed to decide that the reasonable effort had been made to ensure that the individual PHI was being sought, received notice of the request, and or failed to receive acceptable assurance that the parties seeking information made reasonable effort to secure a qualified protective order. And so I am in favor of the plaintiff. The plaintiff's privacy was clearly violated by the hospital when they gave out her information without her permission or knowledge. She did not and could not consent to it because she was not aware. This violation was clear and obvious. The induction of the HIPAA Act in 1996 made patient health information protected by federal legislation. The Joint Commission is committed to continually making improvements and keeping healthcare safety for those they care for. They evaluate healthcare organizations and ensure that they excel in providing safe and effective care of the highest quality and value. Yes, a subpoena was issued, but it was not accompanied by a court order. Let's make that very, very clear. These are two different things. A subpoena is issued by someone other than a judge, seeks a court clerk or attorney in a case, is different from a court order. A HIPAA-covered provider or plan may disclose information to a party issuing a subpoena only if the notification requirements of the privacy rules are met. Before responding to the subpoena, the provider or plan should receive evidence that there was reasonable efforts to notify the person who is the subject of the information about the request, so the person has a chance to object to the disclosure or seek a qualified protective order for the information from the court. The question is, was there reasonable attempt made to contact the party, and was there satisfactory assurance? No. It could not have been proven by the hospital because there was none. According to the Privacy Right Clearinghouse, a covered entity may not use a disclosed PHI unless HIPAA allows it or the patient authorizes it in writing. This general rule may sound clear-cut, but in fact is very difficult. Individuals have the right to receive a Notice of Privacy Practices, NPP, describing how a provider or health plan uses and discloses protected health information. Patients should receive the NPP on their first visit to a provider, and the provider should post the notice where the patient may see the notice in the office or facility. Health plans such as insurance will typically mail NPPs to patients. An NPP must describe how the HIPAA privacy rule allows the covered entity to use the disclosed PHI and states that it will request the patient's permission for only other reasons. It will tell the patient about their right under the HIPAA privacy rule. It will tell the patient how to file a complaint with the covered entity. It will tell the patient how to file a complaint with the HHS Office for Civil Rights, OCR, which is responsible for HIPAA enforcement. It will provide information about a patient's right to restrict fundraising solicitations, and it will explain the need to obtain a patient's written authorization for marketing or the sales of a patient's PHI. The HIPAA privacy rules uses the term consent and authorization. These are two terms that are easy to confuse and must be described because they have very different degrees of patient control. Authorization is much more formal than consent and involves a patient's granting signed permission. For example, a covered entity may but does not have to get patient consent when it discloses protected health information for treatment, payment, or healthcare operations. When it comes to obtaining consent, covered by entities have a lot of discretion, and even if the covered entity chooses to obtain consent, it may be very informal. HIPAA covered entities must make reasonable effort to limit their use or disclosure of PHI to the minimum necessary to accomplish the intended purpose. It is up to the covered entity rather than the patient to determine what minimum necessary means. Also, there are some situations to which the minimum necessary standard does not apply. For example, it does not apply to information disclosed in connection with treatment or when a patient authorizes a use or disclose of information. In conclusion, I am in favor of the plaintiff. Is that 6 minutes?